Welcome back to another edition of Between Two Fars. I'm Warnecke Miller, and I am joined by a very special guest star today, Michele Collins. She is one of the subject matter experts for ethics law at the Johnson Space Center Office of General Counsel. Michele, thank you so much for joining us today and helping us just get a little bit of an overview on the ethics for competitive procurements.
I'm happy to be here and looking forward to teaching everybody some of the rules that go along with being a federal employee and how those will apply to your service on a competitive acquisition. These are just some of the rules. This is just an informational video, so just make sure that you are still attending your ethics training, and always feel free to reach out to any of the ethics attorneys in our office if you have specific questions.
All right, we've got a couple of other cameo appearances today, Michele. Let's go to the first one with Cody Corley.
Do be aware of your personal relationships, even friends and social acquaintances, and avoid the appearance of impropriety.
Yeah, that's right, Cody. The federal acquisition regulations hold us to a very high standard of conduct. We must conduct all of our business in a manner that's above reproach, with complete impartiality and preferential treatment for none. At the bottom of all of this, all of your activity must be done in such a manner that you would have no reluctance to make a full public disclosure of all your actions. This is important because recently, just last year in September of 2020, the Teledyne Brown case was issued by the GAO against NASA. This was a difficult situation in that a NASA employee had a long-term friendship and played competitive foosball on a regular basis with a bunch of college friends. But these college friends also worked for some of the interested parties in the procurement that this individual was working on. So because there was a conflict of interest between the NASA employee's work on the source selection panel for this procurement and his friendships with these individuals who held positions within the interested parties, NASA was sent back to the starting line. Years of procurement work, an award to SGT were canceled, and NASA was told to go back again, cancel the RFP, begin the acquisition anew, and proceed without involvement of any individuals who have a conflict of interest. In addition, they had to pay SGT for the termination of convenience of the contract that they were awarded, and they had to reimburse Teledyne the costs associated with filing this bid protest, including attorney's fees. So it's very important for you to keep in mind all of your relationships, not just the people within your own household, your spouse, your children, but any integrated friendships you have, people that maybe you socialize with on a regular basis, or you have a long-term friendship with. Please keep all of these connections in mind when you're deciding whether or not you can participate on a source board.
Do not accept invitations to attend contractor-sponsored events without considering the impact to your procurement.
Thanks, Tiffany. So an invitation to attend an event for free could be a prohibited gift under the ethics regulations. There is an exception that may apply to such invitations if the event is considered to be a widely attended gathering, commonly known as a WAG. You should contact your legal representative for this determination. There are various other exceptions in the ethics regulations that allow employees to accept otherwise prohibited gifts. However, due to the sensitive nature of procurement acquisition activities, it is prudent to consider declining an otherwise permissible gift to uphold the integrity of the procurement process.
Don't chat about procurement sensitive matters with individuals who aren't cleared for your source evaluation board.
So the Procurement Integrity Act prohibits employees supporting competitive procurements from disclosing both contractor bid or proposal information and source selection information before the award of the contract. Additionally, it also prohibits individuals who are not cleared to support these activities from knowingly obtaining such information prior to the award of the contract to which that information relates. Restriction on communications related to competitive procurement activities also applies to communications with industry. The agency will issue a blackout notice, which occurs when the final request for proposal is issued. Those notices generally say something along the lines of, effective immediately, all NASA personnel will cease communications with industry concerning this particular procurement, and the blackout period of communication will continue through the receipt and evaluations of proposals, the award of the contract, and the release of the board members from their responsibilities. It also refers questions to the specific contracting officer for the source selection. Please be aware that caution with sensitive information occurs long before a blackout notice is issued. You may be allowed to speak with industry about the procurement before the notice is issued, but you should only share information that is publicly available. You can always reference the website for the procurement for details or contact the contracting officer.
Yeah, Michelle's right. And that website for the procurement will have a link on it that allows individuals within industry to submit a question directly to the procurement board. And those questions are publicly answered and posted as well.
If you own stock in a company that does business with NASA, make sure the value of that stock stays below $15,000, or you could have a criminal conflict.
What Amy is referring to is a disqualifying financial interest under 18 U.S.C. 208, which is the criminal conflict of interest statute. This statute prohibits you from participating personally and substantially, such as serving on a board, from a particular matter, which would be the contract, that would have a direct and predictable effect on that financial interest. To state it simply, you should not have duties that relate to a company if you have a financial interest in that company, which includes stock ownership. There is an exception that may allow you to participate if the financial interest is stock and you own less than $15,000, but it is your responsibility to ensure that the value of the stock does not go above $15,000. Once it does, it's a violation of 18 U.S.C. 208. Sector funds are another example of a financial interest that may create a conflict based on the holdings in that sector fund. Please be aware of the sector funds that you own and whether those funds contain stocks for interested parties. If you have any questions, please refer them to your legal representative who can help walk you through the restrictions and any exceptions that may apply.
Do report any new offers of employment with interested parties that may be made to you, your dependents, or household members.
That's right, Dawn. If you or a family member receives a job offer from an interested party, you need to stop your participation, report the offer to your management and to the assigned legal representative to the procurement. The attorney will discuss your options related to employment offers or how offers provided to family members or household members may affect your participation in the activity. If you have been offered employment by an interested party and have responded with anything other than a rejection, you are prohibited from participating in the competitive procurement matter. If an employment offer reaches negotiations, you could be in violation of a criminal statute if you have not already disqualified yourself from participating. Your options are to completely reject the offer and resume your participation, or if you want to pursue the employment offer, you should recuse yourself in writing. If a family member or member of your household is offered employment by an interested party, the assigned legal rep will advise you on whether there is a regulatory conflict of interest and if you should recuse yourself. We frequently see questions related to family members working for contractors or being offered summer internships. Please be mindful of these restrictions and reach out to the assigned attorney if you have any questions.
Do reach out to your legal counsel if any unusual situation or request raises a red flag in your mind.
If a situation arises while you are participating in a competitive procurement, please stop your participation and reach out to the procurement's assigned attorney. Generally, if you have ethics questions not related to a specific procurement, you can send your issue to the legal office to be reviewed by one of our ethics attorneys. The best way to contact the Office of General Counsel JSC is by emailing jsclegal@nasa.gov. Our legal assistant will assign it to one of our ethics attorneys listed here, and you will receive a notification on who your action has been assigned to.
That's right, Michele. Your local attorneys are always here to help. Whenever there's a red flag that goes up in your head or you just have a question, reach out to the local legal office and they'll be happy to help. Remember, this is just a general overview of some of the ethics considerations that you need to think about when engaged with source board activity. We really appreciate you taking the time to be with us today, and we'll see you again next time between two FARs.